Yes, Mr. Stewart.
Before I continue, can I just pick up on one point raised by Lord Carnwath? And the answer, I think, to your question, we understand, is that the consultation paper actually came out before Climate Benson was decided. So it didn't deal with it.
Was that within my time? Never mind.
I'm not sure about
It doesn't matter.
Certainly,
Curiosity. Yeah.
it couldn't deal with what was said in Climate Benson. I was just going to move on to the inconsistency of the approach in DMG with the law on mistake. And I was proposing to illustrate this by looking at the facts of Woolwich. Now, we know that Woolwich made a payment. It was actually a payment of some £42 million on the 16th of June 1986. You can find that in the Woolwich case. The judgment of the House of Lords establishing that the regulations were ultra vires was given on 25th October 1990. That was in the judicial review proceedings, the Woolwich judicial review proceedings. Now, everyone agrees that Woolwich did not make a mistake. They did not make their payments under a mistake. Woolwich believed fervently, on the basis of advice, that the payments were not due.
And they said so at the time, didn't they? They wrote covering letters.
They said so to the revenue, exactly, yes. So they were paying, but they paid for various reputational reasons. But they didn't pay because they believed the payment was due. And there's statements by a number of judges to this effect, particularly in DMG, in fact, but also in Climate Benson. Now, let's take another building society, because there were a number of building societies at the time. They hadn't had the same advice that Woolwich had had. They simply believed the payments were due. And they made the payment on the same date, let's say, 16th June 1986. So it's not unlikely, because I think these payments were made quarterly on certain dates. So they made the payment on the same date. They did pay under a mistake, because they mistakenly believed the payments were due. Let's suppose a few weeks later, that building society was given the same advice that Woolwich had had, and came to the same conclusion that Woolwich had, that in fact the payments were not due. They had exactly the same state of mind as Woolwich had when they made the payment, when Woolwich made its payment. We know that they paid under a mistake. Had they discovered the mistake? Well, according to DMG, no. They couldn't discover their mistake until the House of Lords gave judgment in October 1990. So although, as I say, they had exactly the same state of mind as Woolwich for the whole period, they couldn't have discovered that they were mistaken. Further, it could have brought a claim for repayment based on its mistake before it was able to discover it, according to DMG. That, we would say, shows that there is something wrong with the principle in DMG. Surely the building society, in my example, discovered its mistake when it got the advice in June 1986. Because at that stage, it was confident, on the basis of the advice, that the money was not due. It had made a mistake a few weeks earlier when it made the payment. But it was now clear to it that it had been a mistake. If that's not right, then you find the position that Woolwich has to bring their claim within 6 years of making the payment, but the other building society can wait and doesn't have to bring its claim until 6 years after 1990. So we would say both of those anomalies, the fact that you could bring a claim alleging mistake before it is said to have discovered or have knowledge of the mistake, and the fact that you can't discover a mistake, although when you're deciding whether you made a mistake, you take account of your subjective views of the law. You can't discover a mistake you made until the court has actually decided the issue. We would submit that can't be right. The fourth head is the policy of limitation. And what we say here is simply, this disturbs the balance between the interests of claimants to vindicate their rights and of defendants to be free from stale claims. Section 32 is an exception to the general limitation rule when the general rule would work in justice. But that's not the case. That's not how it is working on this construction of 32.1c. It is not a function of 32.1c to incentivize claimants to wait to bring their claims. It's the very opposite of the normal policy of the Limitation Act, which is to encourage claimants to bring claims promptly and not to sleep on their rights. And fifthly, question of injustice. It works against the security of receipts for the revenue in this particular case and for other defendants in analogous cases. The result is enormous claims going back decades. The assumption by Lords Gough, Hoffman and Hope that change of position in particular would prevent injustice has been proved to be wrong. We now know from this case itself that it is not possible for the revenue in these kind of circumstances to rely on change of position. And you find that in the judgment of the Court of Appeal at paragraphs 309 to 3112, where they reject the claim of the defence in this particular case of change of position. The problem being that for change of position, the defendants have to show a direct causal link between the payment they received and the change of position, i.e. the expenditure or whatever that the money that they paid out. So it works in a simple case where an individual has received a windfall and spends it on a holiday, thinking it's his money. And in simple cases, I think they mentioned the Philip Collins case of the band. But it doesn't work in cases involving large corporations or large organisations such as the government. In any event, we would say it's difficult to see how when we're looking at the construction of Section 32.1c, how a particular construction of an act passed in 1980, consolidating a provision originally passed in 1939, could be justified by a defence which was not recognised until, I think it was 1992, certainly the 1990s, by Lord Gough. And the next, and in a way one of the most important points, is that this decision is fundamentally inconsistent with the law on extending limitation periods in other contexts of the Limitation Act. And I'm going to take you first to the case on fraud, discovering fraud, which is Law Society and Sefton, which you'll find in Authorities Bundle 2.
I was just thinking, Mr. Ewart, that I said at first instance in Law Society and Sefton that the limitation law favours early vesting of claims.
Yes.
But I'm afraid I lost in both the courts above.
Only on one point, as you were
3-2 in the Court of Appeal and 5-0 in the House of Lords.
Who's counting?
I'm unrepentant.
You were upheld on the point that I'm relying on.
Oh, good.
So
I thought I was on it.
you upheld Lord Briggs. My Lord.
That was you.
On this point, I'm going to It's tab 16 in Authorities 2, MS 556.
Wasn't Newberg was in the minority, wasn't he?
He was, yes,
Yeah.
agreeing with me.
There we are.
For those who weren't in the case, they might like to just read briefly the head note. If we could then turn to, first of all, the judgment of Lord Justice Newberger, page 1043, MS 586.
He was dissenting on something, wasn't he?
He dissented, he thought the judge was right on the negligence point. You find that in paragraph 104. But he then went on to consider the other issues. And I think
I see.
the other two agreed with him on those issues.
Yeah.
Your Lordship and Lord Justice Morris Kay agreed with what Lord Justice Newberger said about these other issues that I'm about to talk about, the fraud issues.
I do remember the case, but not for these sort of points.
Yes. So the second issue, when did the Society's alleged cause of action fraud first accrue? And if you wouldn't mind reading from 109 to 113, I'll pick it up there. So he said, you'll see at 114, he sets out the third step in the reasoning, one which would primarily be characterized as inference. It was that a half month's in 2002 represented sufficient time for the Society from the first time it first considered the question of fraud to start an action based on fraud. And applying the test required by section 32.1 as explained by Lord Justice Millett, further developed by the judge in his first step, the judge was not satisfied with reasonable diligence. The Society could not have reasonably discovered the fraud by 2nd December 1996, i.e. more than 6 years before 2nd December 2002 when the action was brought. On this appeal, Mr. Dutton attacks the first and third steps, but realistically raises no challenges to the second step, which is a matter of fact. And it's the first step we're interested in. So far as the first step is concerned, I consider the judge was right in his conclusion that it's inherent in Section 32 of the 1980 Act, particularly after considering the way in which Lord Justice Millett expressed themselves in Paragon and Thackeray, that there must be an assumption that the claimant desires to discover whether or not there has been a fraud. Not making any such assumption would rob the effect of the word could, as emphasised by Lord Justice Millett, of much of its significance. Further, the concept of reasonable diligence carries with it, as the judge said, the notion of a desire to know and indeed to investigate. I accept that one must be very careful about implying words into a statutory provision, and it can be said that the judge's first step involves doing just that. However, it appears to me that the judge was not seeking to imply words or a new concept into the statutory provision. He was explaining what was involved in the process of deciding whether a claimant could, with reasonable diligence, have discovered the fraud, which he now seeks to plead. And as I said, if you turn over to page 1048, MS 591, you will see that Lord Justice Morris Kay says he agrees with Lord Justice Neuberger's conclusions and his reasons in relation to the second and third issues. This was the second issue, namely when the cause of action fraud arose. But he reached a different view on the date in which the Law Society's cause of action negligence accrued, which was the point at which Lord Justice Neuberger was in the minority. And Lord Justice Carnwath on page 1052, paragraph 150, like Lord Justice Morris Kay, and in disagreement with Lord Justice Neuberger, I differ from the judge's admirable judgment on one point only. That is the date when the cause of action accrued. So everyone agreed on what Lord Justice Neuberger said on the second issue, which is what I've just been reading.
That wasn't appealed, I think, was it?
Yes, it was.
It was appealed.
But this point wasn't
Case did.
The case, and I think
the point about when the point of negligence arose was appealed, but not this issue. Yes, that point was appealed.
no, I mean I remember that.
Yes. Yeah.
This point was
This point wasn't.
yeah.
So what you get out of that is that the provision on fraud, which is identically worded to the provision in 32(1)(c), imports the idea that the putative claimant desires to discover his fraud or his mistake. So you're assuming that you're looking at someone who wants to discover it. The question that you're asking is, could he, on the basis of what's around, could he, with reasonable diligence, have discovered the mistake? And what's also important, as you see, is that the limitation period clearly does not start when the fraud is determined by the court. It starts at a much earlier stage than that. Doesn't start when the court has decided there has been a fraud and therefore you know you've got a cause of action. Now, in their written case, paragraphs 90 to 105, the respondents accept that this approach, the Sefton approach, is reasonable in the context of fraud, concealment, and we say presumably mistakes of fact. And they say this is because all of these relate to factual matters which can be discovered sufficiently to commence an action without resort to the court. However, they say the difference, law is fundamentally different because it is impossible to know the true legal position until the court declares it. Now, this we would say is, this argument is circular because it assumes that one has to know the true legal position before the limitation period commences. In all other cases, and I'm going to take you to some other ones, but you can see in all other cases in section 32, a claimant does not have to know the true position, but be in a position to commence or consider commencing proceedings in order to determine the true position. And it's at that point that the limitation period begins. So in the fraud case, when he's in a position, he has sufficient material to launch proceedings. That's when he discovers the fraud, or that's when he could discover the fraud. Whether he does or not is another factual question, but he could, with reasonable diligence, discover the fraud at that point.
No one's thought this relevant in DMG, did they? It wasn't cited.
Lord Brown did.
Does he cite it?
He mentions the fact that it's different for fraud and concealment, etc.
Does he mention the Sefton case?
Well, I don't think he doesn't mention Sefton. No.
He just assumes it's different.
But I think he just assumes that's right.
Yes.
He assumes that Sefton is correct. I mean, if you look at what Lord Brown says, he does mention this point about fraud and concealment being different. it doesn't look like anyone else thought that point was relevant in DMG. The others don't mention
No,
it.
it doesn't seem to have been cited in argument either.
Sefton wasn't. You mean, I don't think, no.
But it's not on the list.
No. I'm not sure. The dates are very close. It would have been being decided round
Well,
about.
no, Sefton was decided in 2003. No, 2004.
This is
I see, maybe it was before that.
2005. Anyway, yeah,
Yes,
yeah. I'm not sure actually that Sefton is necessarily making new law. I think it probably was a position before. I mean, certainly I think Lord Brown.
no, but I mean, since they both come within the same subsection of Section 32, one would have thought someone other than Lord Brown might have thought.
Thought it relevant, yeah. I think everyone assumed that law, as the claimants have said, law was different because you can't discover it. That's what they said, in fact, didn't they? Remember Lord Hoffman said, the truth didn't exist until the court said it. So they seem to be regarding law as being different.
Well, I mean, the trouble is, it doesn't really fit with the rationale underlying Section 32. I mean, just presumably to relax the. I mean, you have the starting point as for the sake of legal certainty, you have a 6-year limitation period under Section 5, and then Section 32 allows that to be extended where it's fair and just to extend it. In relation to fraud, concealment, fraud, and mistake, until the mistake's reasonably discoverable. But if you interpret it as on the basis that a mistake of law isn't discoverable until a final court of appeal has decided the point, then you're way past the extent of the lengthening of the period, which would be justified on grounds of fairness, for example.
Yes. Well, that's exactly the point we make. Exactly, yes. Because you'd think, we're of course assuming it applies to law, but you can see how it reasonably easily applies to fraud and concealment and mistakes of fact. You discover all of those when you have sufficient information to be able to bring an action. I don't think anyone would disagree with that as being the position. It's just that law seems to be treated in a different way.
And in that context, you would think about, for example, whether somebody had been put on inquiry, and having been put on inquiry, had taken reasonable steps.
In relation to things like fact, you can see that. Yes. But they also have to, well, of course, what's being said in Sefton is, it's not a question of whether they've actually been put in inquiry. The question is, if someone was desiring to know,
Yes.
could they discover it?
Yeah.
Could they, with reasonable diligence, discover these facts? Or are these facts that are hidden, for instance, are they in confidential files in the government that you can't get hold of? Or is it a question of, is this my father, which you can't discover because there isn't scientific knowledge which allows you to do it? That's the kind of context in which you would expect it to arise. But law is completely different, as I said. I'm going to turn now to section 11 and 14 and just show you the same kind of approach being taken, going back to AB in the Ministry of Defence, which is in Bundle 1, Authorities Bundle 1, Tab 7. MS 40. And so the lead judgment was Lord Wilson, and the critical passage begins it's on page 94, paragraph 12, which is MS 56. Perhaps you might read paragraphs 12 down to the beginning of paragraph 15, which I think is where he sets out his reasoning. And it's particularly paragraph 12. The belief must be held with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the proposed defendant, taking legal and other advice, collecting evidence. The only other point in Lord Wilson's speech I might just draw attention to is paragraph 27, just below letter F. Lord Wilson makes the point, just above letter F, but in line with the realistic concession made by Mr. Dingemans in this court, the fact is that for the reasons set out by Lord Phillips in paragraphs 156 to 158 below, their claims have no real prospect of success. And that's a reason why he didn't exercise the discretion under Section 33 to extend the limitation period. So that was a point I was making earlier, that the limitation period has been held to have started to run, in this case, years before 2012. But even at 2012, the claimants had no reasonable prospect of success in their claim because they weren't able to find sufficient evidence to substantiate their claim. Despite that, the limitation period has already expired. Then we have Lord Walker, who's the next judge, and I think we can pick him up at paragraph 65, page 111.
Electronic.
Sorry, it's 73, MS 73, paragraph 65. And it's 65 to 67, if you'd like to read those. And then Lord Brown, paragraph 69, I too would dismiss these appeals for the reasons given by Lord Walker, Lord Mance and Lord Wilson. I do not believe there are any significant differences between the three judgments, but if there are, and if something approaching a canonical text is required, I would align myself principally with Lord Wilson's reasoning. Perhaps the most critical proposition to which each of the above three judgments commits is, in Lord Wilson's words, is it a legal impossibility for a claimant to lack knowledge of attributability for the purposes of Section 14.1 at a time after the date of issue of his claim? And then he goes on. If you could perhaps just read down to the end of to paragraph 75.
What are they actually interpreting there? Which bit of the section are they interpreting?
I was going to I was going to come to that. It's a question of knowledge.
Yes, well, I know. I was just trying to see where the statute's set out, but it's
Yep.
on page MS 82, isn't it, in Lord Phillips's. Quite interesting, because he obviously is
Yes,
struck by the wording of the section.
it's a person's date of knowledge, a reference to the date on which he first had knowledge of the following facts. And then 2, about injury. And the disagreement between the minority and the majority, my lord, was the majority thought it was knowledge which gave sufficient confidence to begin investigating proceedings. The minority thought it required a reasonable belief, i.e. a belief supported by objective evidence. That was a disagreement.
What's interesting is that knowledge includes that the injury was attributable in whole or in part to the act or omission which is alleged to constitute negligence. So you are said to know that, even though at the time you sign your pleading you are simply alleging that.
Yes.
I mean, it does seem to involve, the majority's view does seem to involve some distortion of the statutory language.
The minority's view it is, yes.
No, the majority's view.
The majority's view, well,
I thought that was one of the points you're making. Is if maybe you're not making that, but if one's asking, what is not knowledge, you don't, you can allege that it's attributable to something, and you sign your pleading on that basis, but you don't know it until the judge has decided it.
well, on one view of what knowledge is, that you wouldn't know it for sure, for certain. Yes,
I
exactly.
mean,
You wouldn't know it in that
that's
sense.
your point, isn't it?
But that's not what it means. Yes, no, that's right. That's right. It's a
Whereas
degree
Lord
of,
Phillips is taking a much more sort of literalist view of the sections, isn't he?
but even Lord Phillips wasn't saying you had to know for certain. He was just saying that you had to have knowledge based on something objective, i.e. there had to be something actually there, which would give you a reasonable belief. And given that there wasn't enough evidence in this case, there couldn't be enough now. So the limitation period hadn't started to run, essentially, I think he was saying. Because they didn't have sufficient objective knowledge at that point. They simply had enough knowledge to give them confidence enough to start looking at issuing proceedings. I think that was the difference between the two.
I mean, where this might be said to help you is that they all seem to be trying to interpret the words of the provision in light of the policy of the Act, when they take a different view of the policy of the Act.
Yes. But they're not, I think the provision that your Lordship alighted on is the provision that the respondents say is the explanation of this case, that it all turns on 14.1b. And we say no, it doesn't. What it's turning on is what knowledge is, what degree of knowledge you have to have in order to start the limitation period running. This. So I hadn't finished off. There's Lord Mance. Perhaps you just read the first paragraph. Lord Phillips and Lord Wilson have expressed radically different views about the concept of knowledge in the Limitation Act. The present appeals concern personal injury claims, and the disagreement relates to the knowledge referred to in sections 11.4b, 12b, 2b, and 14. But parallel disagreements must necessarily exist between them with regard to sections 11a, 4b, 5b, and 14a. The correct resolution of this disagreement is of general importance. So he saw it as a general question about what's meant by knowledge. In my opinion, Lord Wilson's analysis is consistent with and correct in the light of prior authority, and is the analysis which makes sense of the statute and its purpose. I agree with his reasoning and conclusions, shall not repeat his examination of authority, but content myself with a few points. First, the statute assumes that a cause of action has accrued, and that facts exist of which knowledge may exist. Such facts include an injury which is significant, which is attributable to an act or omission now alleged to constitute negligence, nuisance, or breach of duty. Attributable here means capable of being attributed or as a possible cause. The facts further include the identity of the defendant and of the relevant act or omission of some other person, and the identity of that person and the additional facts supporting the bringing of an action against the defendant. The assumption that cause of action and relevant facts exist favours the claimant. They are taken as given. There is no investigation at this stage as to whether they can be made good. The facts to which paragraphs A to D of section 14.1 refer must be ascertained from the way in which the claimant puts his or her case in the proceedings which are being pursued. Lord Justice Hoffman encapsulates this in a much-quoted sentence in Broadley. Section 14.1b requires that one should look at the way in which the plaintiff puts his case, distill what he is complaining about, and ask whether he has in broad terms knowledge of the facts on which that complaint is based. And I would emphasise asking whether in broad terms he has knowledge of the facts. It's not necessary for him to have knowledge of the facts to determine every single in and out point, but just in broad terms, has he knowledge of the facts on which the complaint is based. This passage was repeated by Lord Justice Hoffman, giving the judgment of the court in Hallam. Significantly, it received full approval by the House of Lords in Howards and Fawcett, a decision under section 14a(5). Lord Nichols, Lord Walker, and I all quoted the passage with approval, with Lord Walker adding at para 66, the court is concerned with the identification of the facts which are the essence or essential thrust of the case, and which distill what the claimant is complaining about. Lord Scott accepted and applied the opinions expressed in Nash, Dobby, and Hallam-Eames that the requisite knowledge is knowledge of the facts constituting the essence of the complaint of negligence. Lord Brown said, what the claimant must know to set time running is the essence of the act or omission to which his damage is attributable. The substance of what ultimately comes to be pleaded is his case in negligence. Applying that to the present case, if I just might for a moment, it isn't necessary for the, if 32.1b is going to apply to mistakes of law, it isn't necessary for the claimants to have knowledge of all of the law that has subsequently come out of the European Code of Justice about, for instance, foreign nominal rates and the detailed way in which the provisions are contrary to European law. What he has to know is the essence of his complaint. And the essence of the complaint, as I will show later on, hasn't changed from the beginning. The essence of the complaint made by the claimants in these proceedings is the same as it was from the very first pleading. It remains the same, and indeed is the point that was being upheld by the European Court of Justice. Then he goes on to say, the speeches in the House of Lords endorsed guidance regarding the concept of knowledge given in a series of Court of Appeal decisions going back to Halford. Lord Nichols said, thus, as to the degree of certainty required, Lord Donaldson gave valuable guidance in Halford and Brooks. He noted that knowledge does not mean knowing for certain and beyond possibility of contradiction. It means knowing with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the proposed defendant, taking advice and collecting evidence. Suspicion, particularly if it's vague and unsupported, will indeed not be enough, but reasonable belief will normally suffice. In other words, the claimant must know enough for it to be reasonable to begin to investigate further. Lord Walker noted at para 57 the numerous cases showing that the starting date may occur at a time when a claimant's knowledge about his complaint is far from complete, that a claimant may have the requisite knowledge, even though he may not yet have the knowledge sufficient to enable him or his legal advisors to draft a fully and comprehensively statement of claim. But that by the time, often years later, that the limitation issue comes to be decided, whether as a preliminary issue or at trial, the claimant's case will have been pleaded and the defendant's act or admission which is alleged to constitute negligence will, at any rate should, have been clearly identified. So I think that's making the point that you still have 6 years or 3 years in personal injuries to investigate and to bring your claim. I refer to the same passage as Lord Nichols. These passages indicate that courts, by using the word reasonable belief as part of the description of the requisite knowledge, are focusing not on so much on whether or how far the belief is evidence-based, but more on whether it's held with a sufficient degree of confidence to justify embarking on the preliminaries to making a claim, including collecting evidence. There is a degree of circularity about such a definition, But this is probably inherent in the concept of knowledge in any context. And then he talks about affirmation. I think I've read this paragraph already. So that's what the majority decided. And as I say, I'm not going to take you to the parts in the minority, but their position was it had to be a reasonable belief supported by objective evidence. And until that evidence existed, then you couldn't have the limitation period, couldn't begin. So they would have simply said that they can carry on trying to find the evidence, I think, in order to substantiate their claim. So this leads us to consider when, on this approach to discovery, could a claimant with reasonable diligence discover a mistake of law? And one has to remember that, as is said in Sefton, it's implicit in section 32.1 that the putative claimant desires to discover whether or not he's made a mistake, and that not making this assumption robs the word could of its effect. If a claimant desires to discover whether it has made a mistake of law, in a case where the law has not been determined by authoritatively, let's say by a court, take that example first, it's hard to see why, in a matter of principle, a claimant could not discover in the Sefton sense. The time at which particular legal points are raised and then litigated is very often a matter of pure random chance, unrelated to the strength or weaknesses of the legal points themselves. It depends on factors such as whether there are claimants who are willing or interested in taking a case at that particular time, whether there is a lot of litigation on a particular issue. The Claimant-Benson case came out of an issue which arose to a lot of banks and local authorities. And so there was a lot of litigation about that, and cases were taken to the House of Lords, whatever. It also depends on the vagaries of the facts. If Woolwich had made a mistake in making their payments, it may well be that the lead case on mistake of law would have been decided in 1992, not in 1998, simply because it would have been Woolwich. But the problem was Woolwich didn't make a mistake. In this particular context, we would submit the FII litigation could have become before Hurst or at the same time as Hurst. There's no reason in principle or in logic why this litigation happened in the particular way it did. It's just pure happenstance. So we would say there is no principled way to determine a date other than the original date when a claimant could, with reasonable diligence, have been in a position to investigate and plead a claim based on the law being different from what he thought it was. There's no eureka moment that you can identify as a matter of principle when you could say, well, before that date they couldn't have discovered their mistake, and after that date they could have. It simply doesn't exist. We would submit. There isn't any way of dealing with it. And when Lord Walker mentioned that it all turned on the facts, he didn't explain why or how it turned on the facts, if you remember in DMG. And this is why I think both parties are, neither party, let me put it this way, neither side, is very keen on the middle ground position. If you remember, we identified 3 positions you could take. One is the DMG position. You can't discover it until the court's decided it. One is our position, which is, in principle, it can always be discovered from day one. And the middle position, which is it's all a question of fact. There is a date somewhere that you can determine as a matter of fact. And neither side has been enthusiastic about the middle ground. And I suspect that's because neither side can really certainly we can't identify any basis on which you could decide that middle ground position. What could you say, just taking our case, for instance, how could you determine a date before which the claimants could not have, with reasonable diligence, discovered their mistake. The mistake being they didn't realise that the provisions were contrary to European law. It's very hard to identify any such date. And of course the difficulty is the onus would be on the claimants to prove that if that was the law. The claimants would have to show on the balance of probabilities that they could not have brought their claims, could not have discovered their mistake with reasonable diligence at any time before a certain date. The date being 6 years. The date being 6 years before they issued proceedings, and that's a crucial issue. They have to show that before 1997, they could not, with reasonable diligence, have discovered this mistake. And we would say that's just an impossibility, because there's no grounds on which you could do it. Why would you say it was impossible for a lawyer to have told you in 1996, 1995, that you had a claim, that this provision was contrary to European law? People told the Hurst claimants that was the case, and they brought claims in 1995. That's a kind of jury point, but the point of principle is why would you not be able to do that?
I'm having some trouble transplanting the concept of a desire to discover, the Sefton concept, or the concepts in the AB case, to a case where you've simply paid some tax. In Sefton, the client had lost some money. It had disappeared from client accounts, so naturally he would want to go and find out why. In the AB case, these people had, I assume, started to suffer from radiation sickness. And generally, in a case to which Section 14 applies, the starting point is somebody's been injured, and therefore is going to want to go around asking, I wonder if it was someone's fault. But yes. I'm not sure that every time I pay my tax bill, I go around thinking, ooh, I wondered if I paid it due to a mistake of law. I mean, I'd lovely if I did, but I don't honestly think I do.
Well, that may be right, but that may be why. Well, that may be one argument why this is not really appropriate for mistakes of law. But the same point would arise if it was a mistake of fact, and I don't think anyone would disagree. You may make a payment due to a mistake of fact, and equally you may say, well, you're not going around thinking about whether it was a mistake of fact, but the limitation period would apply to you, and I think you would be regarded as desiring to discover, and the question would be, could you have discovered it?
If you wanted to.
If you wanted to, exactly. That's the acid test. And if you could discover it, if you wanted to, this goes back to what Lord Reid said, that there's no injustice in the limitation period beginning at that point. That's the point. Now, you may not, in fact, ever discover it, but then that often happens in cases. People don't discover their rights until the limitation period has run out. That's not uncommon. If they're not able to get an extension for some reason, then they may well find that at the time they've actually discovered it themselves, although they could have discovered it earlier, they didn't. By the time they actually discovered it, the period has expired and they can't bring their claims anymore. That's often the case. So we say if 32(1)(c) does apply, then you're really driven to the conclusion that, well, either DMG is right, and we say it can't be right for the various reasons we've given, or that either it's a question of fact, but it's not possible really to identify what the issues are, or the position is, in principle, you could always discover a mistake of law. Because the law, and this is where law is very different from fact, the law is not hidden. There is never a situation with the law where you can say, well, there was some document that I couldn't get hold of, which meant I didn't know what the law was. Not in England, anyway. That may be the case in some countries, but it's certainly not the case here. The law it's an important principle that the law is public. It wouldn't be the law if it wasn't public. So it is quite different from fact.
Give an example where this might apply to someone paying tax under a mistake of fact and seeking to recover later. I mean,
Well, if you if you paid your tax and then you forgot about it and you paid it again, that's a common example. Your mistake of fact is that I believed I hadn't paid my tax when in fact I had. That would be...
don't do anything about it for 6 years, you're stuffed.
well, if it's a mistake of fact... Well, as I said, it's complicated now because if you did it now, then you have to recover under the statutory provisions. But in the past...
But there aren't any examples in the past that you know of where this...
Someone has tried to recover a mistake of fact and fought
Against
it.
the revenue, yes. Well, not necessarily forgetting, but some other mistake of fact. I understand.
No, I'm not aware of any. I'd imagine in practice, if someone had made a mistake of fact, they would probably get the money back. I mean, certainly if they paid twice, they would get it back.
Less than a few billion, yes.
But no, I'm
It
not
would just
aware.
appear as a credit on your next tax account.
Yes,
Sorry.
but your lordship's right. In principle, prior to the 2010 changes, you could have made a claim in mistake of fact. There are a number of what I would call miscellaneous points, which the respondents raise, I think mainly in the context as to why you shouldn't exercise the practice direction, if that is still correct language nowadays. I don't know whether the practice direction really still exists, but why you shouldn't depart from the previous cases. One of these is the Law Commission. The Law Commission considered this in 2001, it is said, and recommended significant reform which hasn't been taken up by the government. And therefore it said this should be a matter to consider by Parliament, not by the courts. The answer to that, the simple answer to that is that this is a matter, what we're looking at here is a matter of statutory construction of Section 32(1)(c). It's not a question of the development of the common law, where an argument like that might have some traction, although it didn't have much traction in Clement Benson for the majority, if you remember, because it was an argument that was run. But it's not an argument in a matter of where it was a matter of statutory construction. And secondly, it's pointed out that legislation has been enacted subsequent to Clement Benson and DMG to ameliorate or reverse the consequences of those decisions. And that's in particular Section 320 and 107. And also there's a provision which imposes a 45% tax rate on restitution interest, which itself is subject to challenge under European law. In response to that, we would say legislation is commonly enacted to deal with perceived or possible flaws in the law. Parliament doesn't confirm by enacting legislation that the flaw exists. It's a very common argument in tax cases because very often by the time the case reaches the courts, Parliament has legislated to remove, if there was a loophole in the legislation, to remove the loophole. And it's often argued that shows that there was a loophole. I've never known that argument to succeed in any court or tribunal. Yes, that's the revenue put it, my learned friend says, unless the revenue put it forward. To the contrary, we would say the opposite conclusion. Parliament signalling that it found that the law declared by DMG to be unacceptable and therefore legislated to change it, supports the case, if anything, for departing from it. Although we would actually say it's a fairly neutral factor. And then finally, it's asserted that there are conflicting academic views. This is in paragraph 78 to 81 of the claimant's written case. However, the views set out by the respondents in those paragraphs by academics concern the central question whether there should be recovery for mistake of law at all, not questions about section 32(1)(c). The only consideration of any depth of the limitation issues that we have found is by Samuel Beswick, and is in the authorities bundle, and is highly critical of the House of Lords decisions. Authorities 2, tabs 25 and 26. Sorry, my lord. Tab 25 is MS 856. And I'm not going to take you through these articles, they really repay reading, but I'll simply take you to the summary on page 857 of the first article. This is a summary of what Mr. Beswick says. The mistake of law category of unjust enrichment might be a more obscure cause of action were it not for section 32(1)(c) of the Limitation Act 1980. That provision postpones the limitation period in cases of mistake. Recent landmark judgments have interpreted 32(1)(c) to extend time for bringing actions in mistake of law till there's been an authoritative judicial pronouncement on the imperative law in issue. This understanding of discoverability is arbitrary, jurisprudentially strained and internally inconsistent. It gives rise to serious problems in doctrine and policy. The court should revisit their jurisprudence and consider the more coherent understandings of the discoverability principle that others have previously advanced. It doesn't sound so it's a ringing endorsement of the previous case law. I think you'll find that there is quite a detailed discussion in both of these articles.
I mean, are they both saying the same thing? As one need to read.
Well, they're both going in the same direction.
Yeah.
I don't think they do say that. I think they.
No,
I think they pick up.
the author, I think, says that the two have to be read together, but what one covers the ground slightly differently from the other.
Yes.
That's my reading of it.
Yes, I think that's right. That's right, Molly. Yeah.
And the other one's in the LQR, isn't it? 883.
883.
Yeah.
He doesn't say it's discoverable on payment.
He doesn't know. No.
Yes, I mean, the essence of his complaint is that claimants pull themselves up by their bootstraps.
Yes.
But because the limitation periods are pushed the point of discoverability to the date that their proceedings reach a final stage.
Yes. Yes. Well, exactly. That's often the case. Yes.
Which determines the legal issue that they're raising.
Yes.
So
they
that's his
can't
criticism.
fail, really. Yes.
Yes.
Yeah.
Yes.
That's right, because very often the case that decides it will be the case that you've brought
Yes.
to determine that you've made a mistake of law.
Not obviously so in this case because of the reliance on the CJEU's judgment in 2006. But if the principle is right, very often that will be the case.
Yes.
Yes.
Well, of course, that is part of this litigation. But I agree, it's not the final stage of it by any means.
Yes. I mean, at MS 873, we I think we have a summary of his view in bullet point form.
Yeah. And then, yes, and then he under that, he says the current doctrine unduly favours the claimants by shielding them from risk. Those who sit in potential claims until the point of law is clearly established. It discourages timely investigation and litigation and hangs a sword of Damocles over long past settled transactions. It affects bad policy and it rests on dubious jurisprudential foundations.
What does Mr. Burrows say? I mean, he would have been party to the law. As if we got an article, we got an extract.
Yes, I don't think he goes into, from memory, I don't think he goes into the point about 32.1c. I think he's more interested in the general question of what is a mistake, etc., which most
He
scholars
espoused the settled law theory, didn't he?
Sorry?
He espoused the settled law relying on settled law isn't a mistake theory.
Well, did he say? No,
Maybe
I don't
not.
think he said it wasn't a mistake. No, I think he says it is a mistake. but he's not. Yes, and that's. I think you tend to find most scholars are more interested in the more general point rather than the more specific point on the Limitation Act. Although, as Samuel Basic says, most of these cases wouldn't have existed without 32.1c. Climate Benson wouldn't have existed, and neither would DMG or...
Nothing in Goffin Jones.
Sorry?
Nothing in Goffin Jones.
Nothing, no, I don't think so.
See
very
one of the
little.
editors here.
There's very little. There is a book on limitation by someone called McKee, and he simply says there's very little on 32.1. So, and I think that's true. I mean, there's very little case law on mistake of fact. Right. What I was proposing to do now, my lord, was to move to, because that is what we say on the issue of discoverability, when it could be discovered, assuming that 32.1c applies. I was then going to move on to the issue, does 32.1c apply to mistakes of law? And here, very good that we got to 3 o'clock in the afternoon. The first issue is the historical position pre-1939. The reason I look at this is because when we come to look at Climate Benson on this, you'll see that most of the reasoning of the two judges who dealt with this point turn on the historical position, in fact. And we would submit that what they say about that is not strictly accurate, putting it mildly. The position before 1939 was there was no, first of all, there was no common law action for money hadn't received based on mistake of law. The common law, the bar existed and there was no action. Equally, there was no claim in equity based simply on a payment made under a mistake of the general law. And you find that in a case called Rogers and Ingham. And now this is, and I hope your lordships have copies of the bundle which we've provided in relation to these submissions. It's tab 19.
Has it been sent electronically?
I'm sorry. Has it been sent electronically? All right. It has been sent both yesterday and this morning, but I'm not sure. All right. It was sent in a zip file, which I think
Oh, the zip.
there was some difficulty.
Tab
It's tab 19.
Rogers and Ingham.
Rogers and Ingham, yes.
Yes, thank you.
So the facts that an executor acting on the advice of counsel in the construction of a will proposed to divide in certain proportions a fund between two legatees One of the legatees was dissatisfied, took the opinion of counsel which agreed with the former opinion. The executor then divided and paid over the fund in accordance with the opinions. 2 years afterwards, the dissatisfied legatee filed a bill against the executor and the other legatee, alleging the will had been wrongly construed and claiming repayment from the other legatee, and held the suit couldn't be maintained. This is in the Court of Appeal. And if we turn over to the judgment of Lord Justice James on page 355, having analysed what the transaction was, he says at the second paragraph, that being so, it is reduced, as it appears to me, to a mere action for money hadn't received. And it is the same as if A, through a third person, had paid B money to B, thinking that B was entitled to it. B, thinking also that he was entitled to it, there having been, as it is said now, a mistake of law which was common to both parties. No authority whatever has been cited to us in support of the proposition that an action for money hadn't received would lie against a person who has received money from another, with perfect knowledge of all the facts common to both, merely because it was said that the claim to the money was not well founded in point of law. Of course, cases of that kind must have continually occurred, and yet no case has been produced in which a suit of this kind has succeeded. And really, when it's treated as a common case of money paid to B under a mistake, the law on the subject was exactly the same in the old Court of Chancery as in the old courts of common law. There were no more equities affecting the conscience of the person receiving the money in one court than in the other court, for the action for money hadn't received produced quite upon equitable considerations. Here the money has got into the hands of one person, and he received it honestly with no mistake on his part, and no mistake on the part of the lady or the trustees, the intermediate handling the money passed that he had actually paid. I have no doubt that there are some cases which it has been relied on, which this court has not adhered strictly to the rule that a mistake of law is not always incapable of being remedied in this court, but relief has never been given in the case of a simple money demand by one person against another, there being between those two persons no fiduciary relation whatever, and no equity to supervene by reason of the conduct of either of the parties. And he then deals with a couple of cases that were said to establish this, and he says of them in the paragraph beginning, that is the nearest case that I've been able to find to the case now before us, but that case is far from establishing the proposition contended for. If that proposition were true in respect of this case, it must be true in respect of every case in the High Court of Justice where money has been paid under a mistake as to legal rights, and it would open a fearful amount of litigation and evil in the cases of distribution of estates, and it would be difficult to say what limit could be placed to this kind of claim if it could be made after an executor or trustee had distributed the whole estate among the persons supposed to be entitled, every one of them having knowledge of all the facts and having given a release. The thing has never been done and is not a thing which is, in my opinion, to be encouraged. Where people have a knowledge of all the facts and take advice, and whether they get proper advice or not, the money is divided and the business is settled, it's not for the good of mankind that it should be reopened by one of the parties saying, you have received your money by mistake. I acquiesced in your receipt of it under that mistake, and therefore I ask you to give it to me back. And then Lord Justice Mellish, I'm entirely of the same opinion. There is no doubt as to the rule of law that money paid with the full knowledge of all the facts, although it may be under a mistake of law on the part of both parties, cannot be recovered back. And I think it's equally clear that as a general rule, the Court of Equity did not in such cases interfere with the courts of law. Nothing, in my opinion, would be more mischievous than for us to say that money paid, for instance, under a mercantile contract, according to the construction which the parties themselves put upon that contract, might years afterwards be recovered because perhaps some court of justice, upon a similar contract, gave to it a different construction from that which the parties had put on it. I think there is no doubt that the rule of law is in itself an equitable and just rule, which is not interfered with by courts of equity. But on the other hand, I think there's no doubt, as it was said by Lord Justice Turner, this court has power, as I feel no doubt that it has, to relieve against mistakes of law as well as against mistakes of fact. That is to say, if there are any equitable ground, which makes it under the particular facts of the case inequitable, that the party who received the money should retain it. And then he asks whether there's any such ground in this case, and concludes that there isn't. And Lord Justice Bagley agreed with them. Now, I think I ought at this point to deal with re Diplock, because that's the case which is said in which it is said, one of the judges says that there is an ability to recover for mistake of law. Diplock is in Authorities Bundle 7, tab 97, and it's MS 2871. This is a famous case in which the executors, by mistake, paid out to the wrong beneficiaries of the will. Those being, I think, mainly charities. You can see in the head note, the executors distributed a large part of the residue among 139 charities before the next of kin of the testator challenged the validity of the original bequest, which was held by the House of Lords to be invalid. Chichester Diocesan Fund and the Board of Finance and Simpson. The claims of the next of kin against the executors or their estates were compromised with the approval of the court, but a number of actions continued against institutions which had participated in the distribution. So what we have here is claims by the next of kin, the disappointed beneficiaries, against the beneficiaries who got the money, not against the executors. Now, as I understand it, the problem was that the executors couldn't recover from the charitable beneficiaries because of the mistake of law bar. They had paid under a mistake of law, and they couldn't get it back. That's going back to the case we just read, the reasoning there. So the next of kin sought to recover it, indirectly, if you like. There are shades of cases like ITC in some of this. And you'll see the claims over the page. The claims of the next of kin were of two main kinds. Claims in personam, based on alleged equity on an unpaid creditor, legatee or next of kin to recover from an overpaid beneficiary, or as he is stranger to the estate. B, claims in rem, based on the doctrine of tracing assets, which are identifiable either unmixed or part of a mixed fund. Now, what we see is Lord, was he Lord at this stage? Lord Green, yes. What he had to deal with was a question of essentially limitation in this case. And if we pick up his judgment at page 480, he says, this is below the code.
You have
Sorry, it's 2886.
thank you.
Now, upon the question whether the mistake he made was one of fact or law, we think the learned judge was clearly right in deciding that it was the latter. And we cannot usefully add anything to what fell from him at that point. Equally, we agree with him that as regards common law claims for money had been received, the action will not lie where the money has been paid under a mistake. It may, we think, be taken to be clearly established that the common law claim is founded upon an implied promise to pay, and that whether by an application of the principle ignorantia juris non excusat or any other grounds, no such promise will be implied where the payment was made under mistake of the general law. It is no doubt true that for certain purposes, for example, the purposes of the application of the statute of limitation, the direct equitable claim by the unpaid beneficiary against a wrongly or overpaid recipient of part of the testator's estate, for it is conceded that in certain circumstances such direct claims will lie, has hitherto been regarded as analogous to the common law claim for money had been received. Both are, after all, money claims. But the common law claim, as may now be taken to be established, is in no sense derived from equity, but is a lineage altogether independent of it. And as the appellants forcibly pressed upon as an argument, in other respects they are marked an important differences between the claim here put forward on the part of the appellants and a claim at common law for money had been received. In the latter, the proper claimant is normally the person who originally made the payment, or is that person's principal or representative, and the claim is made against him who received the money or his representative. It is indeed difficult to see how, save between the parties to the original transaction, or between parties linked by a relationship such as that of principal and agent, any implied promise to repay could be imported. In the present case, the payments were originally made by the executors, and it is in our judgment impossible to say that in making the payments, the executors were acting as agents or in any way on behalf of the next of kin, of whose rights and existence the executors were entirely ignorant. Plainly, nothing that the next of kin have done can be said to have involved any ratification or acceptance on their part of the executors' acts. Further, whatever may have been the nature of the mistakes made by the executors, the next of kin have never made any mistakes at all, whether of law or of fact. So what he's saying here is they don't have an action. The next of kin do not have an action against the other beneficiaries, the charities, on the basis of money hadn't received, because they didn't make any mistake and they haven't made the payment. So it's, as I said, it's a bit like, in some respects, like ITC, that there wasn't a direct payment. In fact, there wasn't any payment at all in this case. So he says, for those reasons, it seems to us that in approaching the question of the existence and characteristics of the direct equitable cause of action, there is not, unless the authority is otherwise established, any necessity in logic for regarding the claim as being clothed, as it were, with all the attributes or limitations appropriate to the common law action for money hadn't received. Nor, on similar grounds, does it appear that there is any conflict involved between law and equity. Equity here, as in other places, comes in, as Maitland has observed, not to destroy the common law, but to fulfil it. Since, for so runs the appellant's argument, the common law can only recognise the two parties to the transaction, payer and payee, or at most third parties asserting the rights of one or other of them. The common law does not, to borrow again from the language, comprehend the whole truth. For the payers in the present case, namely the executors, were handling not their own money, but the money of others who had a proprietary interest unknown to and unrecognised by the executors, and who, from the moment when they became aware of their own rights and the transactions of the executors, immediately challenged and repudiated what the executors had done. Nevertheless, if the claim in equity exists, it must be shown to have an ancestry founded in history and in the practice and precedents of the courts administering equity jurisdiction. It's not sufficient that because we may think that the justice of the present case requires it, we should invent such a jurisdiction in the first place. So, what was going on here was that it was an attempt to impose a limitation period on the claims. Now, if they were claims for money hadn't received, there would prima facie be a 6-year limitation period. And these claims were made more than 6 years after the relevant time. However, what the Court of Appeal decided was it wasn't such a claim, but it was a claim which had a 12-year limitation period. A different kind of claim in equity. And they were within the 12-year limitation period. So that is what the Court of Appeal decided. They decided it, for the reasons they gave in the passage I just read, it wasn't analogous to a money hadn't received claim, but it was a different type of claim based on the equity, based on the fact that the executor, the next of kin had a proprietary interest in the money which the executors had paid out, and that there was a 12-year limitation period for that. But Mr. Upjohn, for the, I suppose it was the defendants, was arguing ingeniously that this was actually a money hadn't received claim. And that's the context in which we see, if we turn to page 514, which is MS 2920.
I'm sorry, just before we move away, you say Mr. Upjohn was arguing ingeniously, but the court, towards the foot of page 480, said that had in fact hitherto been regarded as analogous to the common law claim. In other words, following through, as I understand it, the logic in Rogers and Ingham, even in relation to a claim brought by beneficiaries against other beneficiaries. Is that what he's saying?
Which page were you?
Sorry, page 480, towards the bottom. You took us through it.
No. At 480 and 481, he's saying that there are differences between the claim put forward here and a claim at common law, because the claim at common law would have required it to be the payer who was recovering.
Yeah, what I was focusing on is the sentence beginning, it's about halfway through the last full para on page 480. It's no doubt true that for certain purposes, for example, application of statutes of limitation, the direct equitable claim by the unpaid beneficiary against the wrongly or overpaid recipient of the testator's estate has hitherto been regarded as analogous to the common law claim for money had and received. So that seems to be the Court of Appeal
saying that
saying that up to 1948, that had been understood to be the position.
and now they're saying it's not.
Well, now they're contemplating that it may not be.
Well,
The reason I call attention to it is that in due course we're going to look at the 1939 Limitation Act.
yes. Yes,
I had understood your argument to be that it wasn't contemplated in 1939, that there would be a claim for mistake of law, either at common law or in equity.
yes.
And I was just drawing attention to the fact that in 1939, even for this rather unusual form of equitable claim, which is proper legatee against improper legatee, it was assumed at that time that the logic of Rogers and Ingham applied.
Except that I will have to come back there, but it doesn't seem consistent with what he's saying around it, which is that it's clear if you look before it, he says it's clearly established the common law claim is founded on an implied promise to pay, and therefore whether an application of the principle, etc., such promise was implied where the payment was made under a mistake of the general law. And then he goes on to make the point that the common law claim wouldn't exist in this context. Therefore, there couldn't be an analogous claim in equity.
Yeah, no, I follow that the court is saying the analogy breaks down.
Yes.
But they seem to be saying everyone thought the analogy applied.
Well, I take your point, my lord.
All right, let's not pursue it further.
I understand what you're saying. I'll come back to that. Yes.
Sorry, you were taking us to
Yes,
another
sorry,
point,
I was taking you on. So we're looking at 514. Top of 514. Further, it does not seem to us surprising or unreasonable that the period of limitation applicable to a claim by a beneficiary against a personal representative should be the same as applicable to a claim by him direct against one overpaid or wrongly paid out of the estate. We therefore conclude that the period of limitation applicable to this branch of the appellant's claim is by virtue of Section 20 of the 1939 Act 12 years from the date when their rights accrued, with the result that the defence of limitation necessarily fails. We add, however, that if we are wrong in this view, it is by no means clear that the respondents are substantially in any better position. If Section 20 of the Act does not apply, then it's conceded that there is no section of the Act which expressly does apply to the case. In that event, Mr. Upjohn relies on subsections 1A and 7 of Section 2 of the Act. So far as material, these are as follows. And subsection 7 is an important one. This section shall not apply to any claim for equitable relief except insofar as any provision thereof may be applied by the court by analogy in like manner as the corresponding enactment repealed by the Act has heretofore been applied. Mr. Upjohn says that the effect of these two subsections is to preserve and perpetuate, as it were, the analogous application of causes of action of this character of the repealed statute of James I. We assume in Mr. Upjohn's favour that the words action founded on simple contract must be taken to cover actions for money hadn't received, formerly actions on the case, and as such covered by the statute of James I. The assumption must, we think, be made, though the words used cannot be regarded as felicitous. Even so, however, we are now able to agree with Mr. Upjohn that the language of subsection 7 is sufficient as regards what we have called David and Froud claims to override what we felt compelled to conclude as the natural and inevitable meaning of the express terms of section 20. It's to be noted that the opening words of subsection 7 are in negative form. This section shall not apply to any claim for equitable relief. The subsection proceeds, except insofar as any provision thereof may be applied by the court by analogy. In our view, the effect of this somewhat diffident language must be to limit the analogous, in the present case doubly analogous, application of section 2 of the Act to claims of a kind for which no express provision is to be found elsewhere in the statute. And then they go on, this is the passage that rely on. Assuming, however, that contrary to our view, section 2 of the Act does apply by analogy to the present case, what is the result? Now, this is where they're now assuming, contrary to all they have decided, the bits we've looked at, that this is nothing like a claim for money hadn't received in common law. They're saying, let's assume we're wrong about that, you still lose. It's what they're saying. So really this is a kind of Morton's fork kind of position. You lose either way. Section 2 of the Act does apply by analogy to the present case. What's the result? We've already given our reasons for thinking on Mr. Upjohn's hypothesis that the accrual of the cause of action cannot be postponed until the right of the next of kin against the executors and their estates have been exhausted. But the previous inter alia of Section 2 are by Section 1 expressed to be subject to the provisions of Part 2 of the Act, which provide for the extension of the periods of limitation in the case of mistake, that is subject to the provisions of Section 26. By that section, whereby Para C, the action is for relief from the consequences of a mistake, the period of limitation shall not begin to run until the plaintiff has discovered, or could with reasonable diligence have discovered, the mistake. In order to avoid any difficulty created for him by Section 26, Mr. Upjohn discerns in the hands of the appellants on this part of their case a double-edged sword, for he says that it is an essential part of their main argument that the appellants themselves made no mistake and are not in any way prejudiced or affected by the mistake of the executors. But in truth, this dangerous weapon is in our view in the respondents' hands, for if they seek to bring the case for the purposes of the defence of limitation within Section 2 and to rely upon the reasoning in Re Blake, they must do so by averring that the cause of action is analogous to the common law action for money had and received. And if they assert the analogy, they must take with it the attributes and consequences. Beyond doubt, it would appear that in the case of an action at common law to recover money paid under a mistake of fact, Section 26 would now operate to postpone the running of time. It is true that no such action would lie where the mistake is one of law, but for reasons which we have already given, we do not accept the respondent's contention that the analogous claim in equity will also lie, only when the mistake is one made of fact. In our judgment, therefore, assuming the analogy, as it must be assumed if Section 2 is to apply at all, the action is one for the recovery of money paid away by mistake, albeit by the mistake of other persons and by a mistake of law. In our judgment on this assumption, it's an action for relief from the consequences of the mistake. No less than would be an action at common law to recover money paid away under a mistake of fact. So what this really is an example of is the court saying, well, even if we accept all these things that we think are wrong, you still lose. Because in order to win, you have to assert something which means you must lose. It's not in any way a decision that any of this is correct. In fact, the very opposite. They've already decided that it's wrong. And that the correct analysis is this is an action in equity based on the fact that the money is, putting it loosely, money belongs to, in a proprietary sense, the next of kin. It's not in any way analogous to a claim for money hadn't received. So really what this passage is doing is just dealing with Mr. Upjohn's argument and saying, well, whatever you say, you can't win. Now, it is certainly true that in equity, a contract could be rescinded due to a mutual mistake as to private rights. And there are a couple of cases that are referred to by the court in Clement Benson in which this happened. One is L. Beecham and Wynne, and the other is Cooper and Phibbs. And there's no doubt that in those cases, that possibility was recognised. If I could perhaps I'll just take you briefly to L. Beecham and Wynne, partly because of the brilliant facts of the case. It's tab 6 in the bundle.
Is that your supplementary bundle?
A supplementary bundle, yes. This case entirely turned on what was meant by a warren of conies. And whether it carried the soil for the grant of a warren of conies, or was it simply a franchise? In other words, the right, I think, to shoot the conies. The problem was it had been assumed that it had been assumed that it didn't carry the soil, and therefore a transaction took place between Earl Beauchamp and Charles Wynne of exchange on that basis, valuing the warren of conies on the basis that it was simply a franchise. It then transpired that there was some valuable minerals underneath, I think, which meant that if it carried the soil, i.e. the land, it was very valuable. Or if it was just a franchise, it wasn't. And so this was an action to set aside the contract, the exchange, on the grounds of common mistake. Now, in fact, what the House of Lords determined in the end was there was no mistake. That they were actually correct, that the warren of conies did not carry the soil. And that's what quite a lot of the case is about. Lord Chelmsford decided, before he went on to consider that, you would think, important question, he decided to decide a number of other preliminary points as to whether, amongst them, whether a common mistake of law or of private rights would be enough to found the equitable jurisdiction to rescind. And if we just take it up at page 233, the paragraph beginning, the cases in which equity interferes to set aside contracts are those in which either there has been mutual mistake or ignorance in both parties affecting the essence of the contract, or a fact is known to one party and unknown to the other, and there is some fraud or surprise upon the ignorant party. It was said by the counsel for the respondents that in this case there was no mutual mistake, but only the mistake of the late Earl, Mr. Wynne, not having been mistaken as to the interest which he had in the East Common. But in considering this part of the case, it has been assumed for the purpose of the argument that the late Earl was under a mistake as to his interest, and thought he was entitled only to a right of warren over the East Common, whereas he was the owner of the soil. Mr. Wynne, upon his assumption, was also under a mistake, as he thought the Earl had only the warren, and the soil belonged to himself. The case must be dealt with, therefore, as one of mutual mistake. Dealing with the case upon this footing, it was argued that the agreement could not be set aside in equity, as the late Earl, at the time of entering into it, knew, or had the means of knowing, what his rights in the East Common were, and at all events his mistake was one of law. Cases were cited on the part of the respondent to show that where a party is put upon inquiry, and by reasonable diligence he might have obtained knowledge of a fact which he remained in ignorance, equity would not relieve him, since he would be to encourage culpable negligence. As already appears, there can be no doubt that if the late Earl, at the time of the treaty for the exchange, had taken the trouble to examine his title deeds, he would have found the grant of 1799 to the duchy to Thomas Pinder. Can it be fairly alleged that culpable negligence was imputable to the late Earl in not availing himself of this information in his possession respecting his title to the common? The reason given for this grant having been overlooked is that the estate came to the late Earl from Thomas Pinder in 1811, but it was considered unnecessary to investigate the title from an earlier period, that the only exercise of rights upon the East Common had been by the father of the late Earl, and himself letting the right of breeding and killing rabbits and receiving rent for such right. And it may be remarked that if reference had been made to the neglected document, the knowledge which it would have imparted would have been of a grant of doubtful construction. I cannot think that, taking all the circumstances into consideration, there was such wilful ignorance or culpable neglect as would have deprived the late Earl of his right to relief if he was entitled to it upon other grounds. So they don't appear to be deciding the question of whether they can do it on grounds of reasonable diligence, but on whether there was culpable neglect or willful ignorance, which is a more general equitable consideration. It also doesn't appear that anyone actually made any mistake of law in this case. It doesn't appear that the Earl actually looked at the documents ever. But I think what's being said is, if he had looked at them, he might have made a mistake because they weren't clear. With regard to the objection that the mistake, if any, was one of law, and the rule ignorantia juris neminem excusa applies, I would observe upon the peculiarity of this case that the ignorance imputable to the party was a matter of law arising upon the doubtful construction of a grant. This is very different from the ignorance of a well-known rule of law, and there are many cases to be found in which equity, upon a mere mistake of the law, without the admixture of other circumstances, has given relief to a party who has dealt with his property under the influence of such mistake. Therefore, although when a certain construction is put by a code of law upon a deed, it must be taken that the legal construction was clear, yet the ignorance before the decision of what was the true construction cannot, in my opinion, be pressed to the extent of depriving a person of the relief, on the ground that he was bound himself to have known beforehand how the grant must be construed. It was further argued for the respondent that the appellant was barred from relief by acquiescence, and he rejects that. He then says on page 235, I've gone perhaps at too much length into the consideration of the question as to the appellant's right to set aside the agreement of exchange, but great stress was laid upon this part of the case in the argument on the part of the respondent. After a careful consideration of these arguments, I've come to the conclusion that supposing a foundation had been laid for the interposition of equity by showing that the Earl had mistaken his right to the East Common and that he was in law the owner of the soil, instead of having merely a right over the surface, there would have been nothing in the objections which had been urged on the part of the respondent to prevent his claim. He then proceeds to the more important question, whether the parties in dealing with each other were under a mistake as to their rights. And then there are pages and pages of construction of the document, including remarks like, if the term warren or free warren does not necessarily pass the soil over which the warren extends, much less can it, warren of a limited character, have that effect. And there's a lot of argument about the use of different terms like warren of Coney's and free warren and Coney warren. But anyway, the conclusion that comes to at the end of all of this is that there was no mistake on a true construction of the deed. He only had the warren, the franchise right, not the right to the soil. And the other judges, I think, concentrate pretty much entirely on that point, whether there was a mistake. And as I say, there's a great deal of recondite argument about this question, which is obviously very important in the 19th century.
What are we to take from this case
what you would
that
take
is
from it
helpful
is
for
that-
this appeal?
That there seems to be recognised inequity, where you're rescinding a contract, where there's a rescission for a common mistake, that the common mistake could be as to private rights, but not as to the general law. They make a very clear distinction between private rights and the general law, and they make the same distinction in the other case, which is Cooper and Phibbs, which is behind tab 5.
One thing it doesn't appear to be concerned with is the limitation statutes.
No, absolutely not, because the limitation statute didn't apply. That's one of the points, of course. Well, Cooper and Phibbs, there wasn't any limitation point, because I think it was only a couple of years after. They were clearly within time on any basis, but the limitation statutes wouldn't apply to equitable relief, such as rescission. They might be applied by analogy in some cases, but they wouldn't actually apply. So again, there is Cooper and Phibbs. You can see that again there was a mistake as to rights to fisheries. You can see from the head note. Again, it's not very clear in this case whether there was actually any mistake of law at all, or whether it was simply that they had believed that they had the rights because they'd been told by their father that they had them. Seems to be the position. So the summary is on page 164. You can see the core of the case. The consequence was, of all the events that had happened, the present appellant, when after the death of his uncle, he entered into the agreement to take a lease of the property, entered into an agreement to take a lease of what was in truth his own property. For in truth, this fishery was bound by the covenant and belonged to him, just as much as did the lands at Ballysadere. Therefore, he says, I entered into the agreement under a common mistake, and I am entitled to relief from the consequences of it. And then they consider whether he's able to do that. And I think it's Lord. So that is the speech of Lord Cranworth. I think it's actually Lord Westbury's speech that goes into this point about law.
It's on page 170, isn't it?
Sorry.
Page
yes.
170.
On page 170. Yes. If
He talks about the general law or ordinary law of the country.
yes. The way it arose was slightly strange. You can see that on page 168 and 169. The paragraph at the bottom of 168 and 169 was that there was a private act of Parliament which on its face appeared to give the absolute fee to whoever it is, the uncle, but recited a deed, which if you looked at the deed, you would see that in fact he was holding it as trustee. And the points are being made on 168, 169, that it must be taken that the uncle had not misled Parliament in enacting the Act of Parliament, and therefore the Parliament must have understood that he was acting as a trustee. And therefore, where they say he took it in fee, I think it was, it must be taken that he's taking it in fee as a trustee, not absolutely. Because his argument was, look at the Act, I take it absolutely, it's mine. But that was rejected. So it was a question of, in the end, a construction of this private act of Parliament based on a deed recited in the Act of Parliament, which you then had to look at to determine what the private rights were, which to some extent explains why this is different from a general mistake of law or a mistake of the general law, because there are more factors in private rights than there are in the general law. You often have to know other things in order to determine them. Although you might say it's a question of law, in a sense, the construction of a document, often it can turn on factors that are not necessarily publicly known, as I think was the case here. So as my Lord Cranworth said, on page 170, the judge says, just above the hole punch, bottom hole punch, private right of ownership is a matter of fact. It may also it may be the result also of matter of law. But if parties contract on a mutual mistake and misapprehension as to their relative and respective rights, the result is that the agreement is liable to be set aside as having proceeded upon a common mistake. That was the case with these parties. The respondent believed themselves to be entitled to the property. The petitioner believed that he was a stranger to it. The mistake is discovered and the agreement cannot stand.
This is a sort of parallel relief to rectification, isn't it? Where for what is sometimes called mutual mistake, which might be the mistake as to the true construction of the document which the parties signed.
Yes.
But it's a parallel jurisdiction because it doesn't lead to the contract being put right, but just being set aside.
Yeah, exactly. Although, yes. Although it then has very often retrospective effect in certain circumstances if it is rescinded. It's often considered not to have been in existence for other purposes, tax purposes, for instance, I think. There's some case law on that. But this is a purely equitable remedy we're talking about here, not.
I mean, all this is going to Lord Gough's point that the 1939 Act applied to mistake of law in equity, and you were saying that's a misunderstanding.
Yes, that's
Well, it was true as regard private rights, wasn't it?
as regards
Generally
private.
recognised.
Yes, but not as regards a general law. Yes, that's right. Yeah.
In a way, we can see Lord Renbury, halfway down page 170, saying private right of ownership is a matter of fact.
Yes,
It may be the result also of matter
yes,
of law.
yeah. I think it is in a sense. That's right. Well,
But
whether
just to
something's
understand that, I mean, you know, whether I own something is, in a simple sense, a matter of fact, even though those facts have been constructed by a whole regime of law which determines property rights.
yes, yeah, and it may be for some purposes something is regarded as a question of law, and for other purposes it's not. For instance, for appealing purposes, there's often questions as to when you can only appeal on a point of law. You may decide that construction of a document is a point of law, but you may not consider it to be for other purposes. I suppose that's the point. But the other point, of course, to make is that whatever the position here, this is not something that the Limitation Act would have anything to say about. So 32(1)(c), the original section 26, would not have anything to say about rescission, except possibly by analogy. In other words, it wouldn't apply because there wouldn't be a limitation period provided in the primary limitation period provided in the statute. So that section 32(1)(c) only applies when there's a primary period in the statute and it extends it. So our position is, based on the historical position, the starting point is there's no reason to think that Parliament would have been thinking or including mistakes of law in section 26 and in section 32(1)(c). And I'll come back to what was said in Climate Benson, because that's important, obviously, to look at, because that was really the heart of the debate there. But we then say further that that's not the end of the matter, because you still have to decide whether, once mistakes of law had been recognised in 1998, whether you should read section 32(1)(c) as including them, although they wouldn't have been included or thought to be included previously. This is perhaps something like the ever-speaking statute.
Quite, yes.
We would say that what we say in our note and what we'd say orally is that the policy of the Limitation Act generally is that limitation periods are not postponed until the claimant understands the legal consequences of the facts, but when he has knowledge of the facts. And that is the position in section 11 and 14 explicitly. If we look at section 11, which is in the first authorities bundle. It's tab 5. Oh, I'm sorry, tab 6, yes, I'm sorry. And section 14 is on MS 34. And it's the words at the end of subsection 1. Knowledge that any acts or omissions did or did not, as a matter of law, involve negligence, nuisance, or breach of duty is irrelevant. So what you do not have to know the legal consequences of the facts, if you like. And we would submit that's the same in section 32. In the other parts of section 32. It's not necessary to discover the legal consequences of the facts that have been concealed, or the mistake of law, or the mistake of facts, let's say, or the fraud.
I don't know if you've looked at this, but one would imagine that in the textbooks on statutory interpretation, Craze, for example, or Bennion, there might be a discussion of the always speaking doctrine and a sort of context in which it's been applied. Because this is obviously very different from, say, the term family being enacted in, say, the 1920s and having a different connotation in society today. Yes. Although it also has a feature that an action has been recognised which didn't exist in law before, and which appears to fall within the wording of the provision. So I suppose there's that different factor here. I mean, that's really the reason, I think, that you might take the view that even though it wasn't within the thoughts in 1939 or 1980, that it can be a construction of the provision.
But that would mean that Parliament's legislated for something that it's never applied its mind to.
Well, that's right.
So,
Yes.
well, I think the question then is that right?
Yeah.
And what is the limits of the doctrine of a statute being always speaking?
Yes, well, what one limit we would say in this context would have to be that it is absolutely in line with the statutory purpose.
Yeah. Well, say, for
If it's
example,
not, then
in the example I just gave of family, you could have a statutory provision that says that on the death of the tenant, the tenancy, then a member of the tenant's family living with the tenant is entitled to succeed to the tenancy. And Parliament might have enacted that at a time when there was a certain conception of what a person's family would be, but when the Act comes to be applied today, there might be a broader understanding of what constitutes a family. But you could say that it's consistent with the intention of Parliament in the 1920s, say that the Act in the 2020s should be given a meaning that fits with modern conceptions of family relationships. But as Lord Sales says, it's rather different to say that because something new has popped up as a result of a judicial decision, the statutory language should be treated as covering it, although it's a different kind of entity from anything that Parliament had in mind at the time when the statute was passed.
that's true. But if we take another kind of example, there are situations where the Act was passed at a time when certain technology didn't exist. So, for instance, I think I remember there were cases about whether a computer file was a document. The legislation talked about a document. At the time it was passed, nobody had ever dreamed of computers. But it could still be held that something which came into existence later, which wasn't thought about, could fall within the definition of a document, for instance, because it fell within the purpose of the provision, say a disclosure or something like that. I think.
But I think that's the Victor Chandler case, isn't it? But that seems illustrative of the point that my Lord Reed was just putting to you. If you can say, in some sense, the new thing that we call a document, i.e. the computer file, is fulfilling the same purpose as the old thing that has always been called a document, i.e. paper, as understood by Parliament at the time it passed the legislation, it may be that it's right to apply the always speaking doctrine to the new thing because it falls within the ambit of the purpose that Parliament always had in mind, even though it couldn't predict computers.
Yes.
But I mean, might it not be said that the policy issues, for example, which arise if you're applying limitation to mistake of law cases as opposed to mistake of fact cases become rather different? So
That's exactly
seems at least to give rise to the question, well, are you within that presumed purpose according to which Parliament legislated in the first place?
That is precisely what we say, my Lord, yes.
Right.
We pray an aid. I don't know if you've had the chance to...
But I mean, I thought the question was whether there was anything in the textbooks which...
well, so that...
Yeah, well,
Quite
that's
often
where
know the answer.
I'm sure there is.
yes, that's where I started off, and it would still be useful to know the answer.
We will look at that.
I didn't want to miss that.
With the rider that I think Lord Hoffman always said that you could find something authority for any proposition in Benyon.
I think that's a bit unfair.
But we will look at that, yes.
You accept it's within the language, do you?
In the sense that it talks about mistake.
Discoverability. Well, we've
Well,
spent
it's
quite a lot of
within the
time
language
this
of
morning
mistake.
on...
I don't accept it's within the... I don't accept that the language of discovery is appropriate, which is one of the points that we make. Yeah.
But
Yes.
also, I think there were some exceptions to the idea that recovery was simply for a mistake of fact. Weren't there some cases where officers of court, if they held on to proceeds or which they shouldn't have, because of a mistake of law, they would still be required to...
I was going to come to that, my Lord. Yes,
okay.
Precisely, yes. And that's a very interesting...
I won't take it out of order if you're coming to it later.
I was going to come to that when I looked at Clement Benson, because that's one of the major points that I think was it Lord Hope.
I think Lord Hope mentioned it in Claimants Benson.
Both mentioned it, yes, exactly.
It was
Yes.
Marty James.
Ex parte James.
Well, Ex parte James, and then there's another a later House of Lords case which summarises the jurisprudence, which I think is probably the best one to look at.
Well, if we're coming to it,
I was going to come to that.
Fine.
But yes, that is something completely different, and we will see it actually isn't even a legal claim, a legal point. It's a matter of morality, essentially. The court is saying we're not going to let our officers behave disreputably by holding on to money that belongs to somebody else, just because it's a mistake of law.
So is it more the exercise of some sort of disciplinary function by the court over its own officers?
Yes, it's quite an extraordinary statement. But
Often cited, but it hardly ever seems to work.
Sorry?
Often cited, but it hardly ever seems to work.
Yes. Yeah, that may be true.
Now,
So I don't know if this is
I think it might be.
I'm well on track to finish well on time.
Very well. Well, we'll adjourn now and sit again at 10:30 tomorrow.